moral principle. Under the natural law school of natural law, only moral values, law equal moral value. Okay? You respect your family is a moral value. Also, you respect your family is a has a binding forces, and respect your parents is a law under the perspective of natural law. Positive law, philosophy of positive law, focus on man-made rules. Under the doctrine of positive law, law is the command, order. Law is the command of recognized political authority. Recognized political authority means government agents. Only government agents have political authority by enforcing political authority have a power to regulate any behavior. Under this positive law concept, just whether the law is just or unjust, it doesn't matter. We must obey the law under the positive law, just like Socrates, okay, in Greece. Okay. Last, philosophy of law is a legal realism. Legal realism. Legal realism is most widely used in this United States of America. The United States of America, legal system of the United States of America is based on the legal realism doctrine. Under this legal realism, legal rules are only based on the actual judicial decisions, because these actual judicial decisions can benefit our society, can interest our society, or only American judges' decision can benefit our American public policies. Therefore, legal realism, American society must be established based on the legal realism. The purpose of law. Over the time, the law was existed and developed from the ancient 5,000 years ago. There existed a law. Therefore, over the time, the purpose of law has evolved, developed, and has changed to ensure the consistency and fairness in our society. Therefore, the law serves many purposes, and the law functions, serves many functions in our society. Two categories of law, civil law and criminal law. The law set out the system of order that defines the crimes and levies is the punishment for the violators, and the law set out the system for resolving the dispute, resolve the controversies between the people by providing a basis for decide the legal interest and decide the legal right of the parties. Legal environment of the business. Legal environment of operating the business. Business law existed to create the reliable standard for the business, for the companies to follow. Every business must follow the business law. Not follow the business law, then government levy the punishment to that business, that companies. Therefore, law serves as an important catalyst booster for the commerce, for the business, by promoting the good faith dealing. Good faith dealing and the faithful dealing. Promote the faithful dealing and promote reliable dealing among merchants and consumers. The American law also provides some degree of reliability that can be considered in business planning and commercial transactions. This chapter deals with the overview of American law. Okay, deals with the only overview of American law. Therefore, not difficult this chapter. Okay, very easy chapter. Lord of Counsel. What is the counsel? Who is the counsel? Attorneys, other name is a counsel. Okay. Attorney is called as a counsel in the England. Business owners and business managers often work closely with the business attorney, business counsel. In-house counsel is an in-house attorney who work for a company, and the attorney are part of executive and middle-level management team. Hiring attorney result in reduced cost and limitation of risk and liability of the business. Okay. There are 4 primary sources of American law. In America, there are 4 sources of law. Constitutional law, statutory law, common law, and administrative law. Constitutional law. What is the meaning of a constitution? Constitution. Constitution. What is the meaning of a constitution? The meaning of a constitution is a structure. Your body structure is sometimes referred as your body, constitution of your body. Your body consists of the bone structure. Okay. Constitution consists of the structure of the government. Structure of government is referred as a constitution. There are 3 branches. Of American government. I'll tell you later. Okay? Constitutional law establishes the important legal principle. Constitutional law is a supreme law, most highest authority. Therefore, describe only the legal principle. Constitutional law does not design to specifically resolve every detailed issues, not resolve every legal cases. Therefore, constitutional law requires the implication by the court, American court. Many judges, many attorneys interpret the constitutional law differently because constitutional law is very broad. Nobody knows exact meaning of constitutional law. Okay? Constitutional law consists of only 24 articles. Okay? Those 24 articles cannot resolve all the controversies between the persons, individual persons. constitutional law exists at the state level of law, state level as a supreme law, or constitutional law exists at a federal level as a supreme law. California state has a California constitutions. Georgia state has a Georgia constitutional law. U.S. federal government has federal constitutional law. Constitution law is referred as a supreme law, highest level of law. Therefore, constitutional law provides the foundation for all other law. There are too many laws: criminal law, civil law, tort law, commerce law, criminal procedure, civil procedure, administrative law, air pollution law. Too many laws. Only constitutional law provides their foundation for all other laws to prescribe, in order to prescribe the basic structure and prescribe the basic power of the particular governmental body. Tribunal government, city government, local government, county government, state government, federal government. Have their each constitutional law. Constitutional law protect certain individual person's right and protect the right of businesses from governmental encroachment, protect any organizations from any governmental wrongdoing. Only constitutional law protect the government, protect the right of any organization from any governmental wrongdoings, encroachment. U.S. Constitution is a supreme law of the land, of the American land. Supreme law of the American territory. Constitutional law establishes a structure for the federal government, establish a structure for the state government. U.S. Constitution enumerate, describe with the powers of the federal government. Federal government can exercise the power only described in the U.S. Constitutions. U.S. Constitution provides the federalism. U.S. government consists of one federal government and 50 states. Under the Arizona versus United States of America cases, landmark cases. And U.S. Constitution supports the civil rights and civil procedure protections. Second source of American law is statutory law. Statutory law is known as a code. Statutory law exists at the state level of law, federal level of law, and local level of law. Statutory law are created every year, every day by a legislative body, Congress, to regulate the conduct, to regulate the behavior. Example of a statutory law is a Clean Air Act. Statutory law is approved or disapproved only by the executive branch. There are three branches: executive branch, judicial branch, and the parliamentary branch, Congress. Okay, executive branch is referred as administrative branch. There are similar terminology. Do not confuse. Example of the chief of executive branch are governor or U.S. President. Trump is the chief of executive branch. Governor is the chief of the state executive branch. Trump is the chief of the federal executive branch. Third source of American law is common law. Common law. There are two legal systems in the world: common law legal system and civil law legal system. There are only two legal systems. Only two legal systems are existing in the world. Common law is a legal system that is based on the written judicial decisions that establish precedent. I will tell you the precedent in the subsequent slide. Judge-made law is referred as a precedent. Judge-made law is referred as a common law. Only appellate court can make the common law. There are three levels of court in the governmental body: trial court, appellate court, and Supreme Court. Common law is based on the fundamentals of previous cases that have similar facts, similar issues. The controversies that have similar facts, similar issues must be resulted in same conclusion under the common law system. Common law does not have a written code of law because every judge's decision is a common law, is a law. Individual judge's decision is a common law. Under the civil law system, individual judge's decision is not important. But under the common law system, individual judge's decision is a law. Very, very important. Nobody contradicted the previous individual judge's decision. The origins of the common law. The U.S. system of common law. U.S. system of common law is come from the England, ancient England. U.S. system of common law is the city in British common law. England common law has developed over several centuries. That is beginning around 1066 AD, Henry VII. Henry VII governance. I told you there are two major legal systems, civil law legal system and common law legal system. Common law legal system is referred as an Anglo-American legal system. Only two nations adopt the common law, American and England. Civil law legal system is referred as a Romano-Germanic legal system. Germany established the civil law legal system. All the Asian countries adopted the civil law legal system. German law. Civil law is based on the only statutory codification of law. Two different legal systems in the world. Okay, very, very important legal doctrine is stare decisis. Stare decisis become more precedent in the America. Still, all the legal terminology, the most legal terminology are come from the Latin word, Roman word, Roman Empire, come from the Roman Empire. Stare means the stand. Decisis means the decision. Therefore, stare decisis is interpreted as a Latin word, as a letter, decision, stand, permanently. Letter, decision, judge's decision, stand, permanently, is a doctrine of stare decisis. Stare decisis doctrine is one of the most important concepts in American law. Under the principle of the stare decisis doctrine, the similar controversies, the similar cases, with similar facts, with similar issues, should have the same judicial outcome. Nobody contradicted these precedent, previous individual judges' decision. All the following judges must follow the previous judge's decision. That is the stare decisis doctrine. The appellate court create the precedent cases, and under this doctrine of stare decisis, lower courts must apply these precedent cases to the new cases. Lower court must apply the past similar precedent case to the future new cases with the similar past, with the similar issues under the stare decisis doctrine. Okay, landmark for the stare decisis doctrine is Brazil versus Pennsylvania hospital cases. Very, very famous cases, landmark cases. The Supreme Court provided that in these cases, stare decisis, channels, guide, this is the law, American law. Stare decisis elects the right house and the signals of safety, but the principle of stare decisis does not demand that we follow the past precedent cases which shipwreck, demolish, which damages the justice. We can have a power. The greater judge has a power. Not follow the injustice decisions under these landmark cases. Final ruling is that although the doctrine of stare decisis plays an important role, standing precedent can be abandoned, demolished to allow for developing society standard of our behavior and of our expectations. New justice can create new stare decisis, new precedent under these landmark cases. Advantage of stare decisis and the business. How these stare decisis impact our business. Stare decisis allow our business to have some degree of the confidences that the existing law will remain reasonably and constantly. These stare decisis require all the lower court, such as a trial court, follow the case precedent so that any similar cases, with similar issues would be decided according to the past precedent cases. I did not commit the wrongdoing because precedent cases is held that I'm not long under the stare decisis doctrine. Case precedent. Once an appellate court has decided the particular cases, case means a law, common law. Case is referred as a common law. Case, common law, same meaning. Once an appellate court has decided the particular cases, that particular cases, decisions become a case precedent, become a common law. Precedent is usually only binding within the jurisdictions of the court setting in the precedent. What is the meaning of a jurisdiction? LA County Police Department has the power to control the traffic on within the jurisdiction of the LA County. Each government has each jurisdictions. Jurisdiction is a power to judge any controversies. Okay. The source of American law is administrative law. Administrative law. Administrative law is a sources of law that regulate the exercise of authority, regulate the exercise of the power by the governmental agencies. Government, administrative, kind of same meaning. Administrative law or governmental law is an agency rule to implement, to carry out the enforcement of a statute. This administrative law is known as regulations. Common law is known as code. Administrative law is known as regulations. Different terminology. Okay. I told you four sources of American law: constitutional law, common law, the administrative law, and the statutory law. There are four sources of American law. In addition to the sources of American law, there are secondary sources of American law. What is the secondary sources of American law? Law school, the law professor's opinion is a secondary source of law. The secondary sources of American law has no independent authority, no independent power. Therefore, secondary sources of American law do not have a legal binding forces. The secondary source of law functions to increase the level of uniformity, to increase the level of fairness across all 50 states except the Louisiana state. Each state has a different constitutional law, different criminal law, different civil law. Therefore, each state law can conflict, contradictory against the other state. For example, selling and buying marijuana is legal in some state, but selling marijuana and smoking of marijuana is illegal in some state. Different. Therefore, secondary source of law, such as the law professor's opinion, functions to increase uniformity across all 50 states. Secondary source of law includes the restatement of American law and secondary source of law set of model statutes, such as Uniform Commercial Code. Uniform Commercial Code, UCC, regulated every economic activities across all of within the American territory. UCC regulated even individual persons raising chicken and the farming activities are regulated under the UCC, Uniform Commercial Code. Bankruptcy, regulated bankruptcy is a bankruptcy is included in the Uniform Commercial Code. Bankruptcy is a federal rule. UCC is a federal rule. Federal rule regulating all of the 50 states. Therefore, secondary source of law is very, very important. In addition to the four sources of American law, uniform, the model statute, very important. Uniform model statute was drafted by legal experts such as the law professor and the attorney institutions, American attorney institutions, the opinion. Uniform model statute was drafted by legal expert in hope that this model, uniform model statute will be used or will be adopted by each 50 state legislatures in order to provide the uniformity in law between the 50 states, because 50 states have the different, each state has a different legal system, different law. Example of uniform model statute are the UCC, Uniform Commercial Code, and RUPA, Uniform Partnership Act, NBC Act, Model Business Corporation Act, and Uniform Protocol, Uniform Contract, restatement of contract, restatement of torts are the example of the uniform model statute. Restatement of law, very important. Restatement of law, very important. Restatement of law is a collection of uniform legal principle because each state has different legal principles. Therefore, restatement of law is a collection of uniform legal principles in a specific area of law, such as the tort law, criminal law, contract law, okay? These restatements of law are designed to reduce complexity of judicial decisions. Restatement of law seeks to inform the judges, to inform the attorneys, to inform the legal professionals about the general principles of the common law. The common examples of widely used restatement of law are restatement of torts and restatement of contract. Okay, category of law, category of American law. Category of American law, the broad category of American law is based on the classification that is related to a particular legal function or legal right afforded by the American law. The category of American law is very, very helpful in understanding the big picture of our legal systems, of our American legal systems. Criminal law versus civil law. We are almost done. Please, I finish this lecture within 7 minutes. Okay, in 7 minutes. Civil law are designed to compensate the parties for the damages, compensate the losses as a result of another person's conduct, another person's wrongdoing. Civil law deals with the private right between the people and people. Criminal law is a protection of our society. And the violation of this criminal law result in the penalties to the violators, such as the fines, such as the imprisonment. Criminal law deals with the offenses against our society. Okay. Okay, substantive law versus procedural law. Substantive law provided the individuals with the rights, and substantive law creates a certain right and duties. Procedural law provides the structure and set out rules for pursuing the substantive right. Okay. Example of substantive law is a criminal law, contract law, tort law. Example of procedural law are the civil procedural law and criminal procedural law. Okay? Law and equity. We use this law and equity term and describe the appropriate measure of judicial action to compensate the injured party, damaged party in a civil law. Where remedy and law. Remedy and law deals with the money damages. However, remedy and equity deals with the justice different. Where remedy and law is inadequate, a damaged party may obtain the remedy and equity. Equity is applied by the equity court to achieve the justice, and legal rules would produce unfair result. These two compensations are known as legal remedies and equitable remedies. Types of remedies. Remedies and law generally take a form of money damages. Equitable remedies includes injunction or restraining order and specific performances. Okay, I skip. This is the history of equity court, history of equitable remedy. This come from the Henry VII. I skip this part because we have more time. Okay? Example of equitable remedy: injunctions or restraining order. Injunction is a judicial order requiring a party to stop doing something. Example is that judge's order prohibiting the construction of 10-foot fences in a residential neighborhood. You cannot build to the 10th floor in this area. Is an example of injunction. You cannot smoke the marijuana in this area. Is an injunction. Specific performance is a court can issue specific performance as an alternative remedy to damage. You are a famous singer and you contract with the owner of a nightclub. Therefore, you must sing a song at a Saturday night in the clubs, the theater. That is the example of specific performances. Okay? You must study hard. You respect your parents. A kind of a special performance? I don't know. The important equitable actions. Maxim. What is the meaning of maxim? Maxim is a rule for behavior. Okay? Legal rules for behavior. Equitable maxims has been developed by early American courts. Equity, aid, vigilant persons, substances, overform, clean hands doctrine is the example of equitable maxims. Equitable maxims are intended to be broad statement of rules. These maxims are based on the notion of fairness and justice in applying the law. Okay. Equity, aid is a vigilant persons. The law favors the people, those who exercise the watchful person, careful person. The law protected the watchful person. And this favor, the law, the judge does not like those who rest on their legal right, by failing to act to protect the right. It means that the judge, like the person who take the watchful, cautious actions, and does not like the person who is very negligent. Okay, substances of a form. And applying the law, the court, the judge, look to the actual substances, look to the intention of the parties, instead of applying the legal form. Okay? Intention is most important to apply the law. Legal form is not important, but not important compared to the intention. Intention is the most important component to apply the law. Clean hands doctrine. Okay, we have two slides. The courts are guided in their decision not only by the letter of law, also the basis, the help the person, like the person. If plaintiff wanted to come to the court, plaintiff, you must come to the court with your clean hand. Only clean hands have legal right to come to the court. If you are unstained by bad faces and unstained by misrepresentations, and you are unstained by deceit, you cannot come to the court to claim your legal right. That is the clean hands doctrine. Kaufman versus Kaufman case is a famous case. The doctrine of clean hands provided that the parties must not expect relief in equity unless they come into the court with clean hands. Dirty hand, you cannot come to the court under these famous cases. Public law versus private law. Okay, last slide. Okay. Public law refers to the relationship between the government and private persons. Public law deals with the regulation of society. Example of a public law are the constitutional law, statutory law, and administrative law. Private law refers to the regulation of the conduct between private persons. Private law deals with the issues that concern private resource relations. Example of private laws are contract law, tort law, and property law.